This is an example of our process. It's actually more detailed than this. We actually have a process checklist that we use every time a client walks in the door. And then I keep track of every client. I know exactly what's happening with any client at any given point in time. We have a Monday morning meeting in our small group where we sit down and we go over every client and the status of every client. So if you refer a client to me, I know exactly the last time when we emailed them, when we called them, when they called us. We keep track of it because I don't want to hear from a client, "You never returned my call." I know that that's not necessarily the case. We did return the call. It's just you didn't recognize that there was a voicemail on the phone or something like that, or we sent you an email. And we're always trying to keep in touch with our clients. We want to be proactive. We never want to hear that the client is not hearing from us, ever. Going backwards, forwards. Okay, so these are the key issues. 30 years ago, everybody used wills. When I started in practice, it was just wills. Very few people used revocable living trusts. I started using them about 30 years ago, and I've been using them ever since. Now everybody uses them. Why? Because we already talked about it. Avoiding probate, planning for incapacity, affordability, privacy. And we had a low estate tax exclusion. It was, 600,000 was an increase in the estate tax exclusion when I was practicing. Then it went to 675. Then it went to $1 million. And then it ramped up during the Bush administration, George W. Bush, all the way up to unlimited in 2010. It was repealed. The estate tax was repealed for 1 year. Now we have a $5,450,000 lifetime gift tax, estate tax, and generation skipping transfer tax exemption. And it's a 40% permanent tax rate. All of these are permanent in the law. Now, we have an election coming up. The Democrats said that they're going to increase the rates and lower the exemptions if they get elected. Of course, it depends on who's running Congress, right? Because Congress is ultimately the ones that are going to make the decision. They can't legislatively enact changes in the tax law without Congress's participation. The other major change in the tax law was portability. The exemption now, if somebody dies without using it, is portable to the surviving spouse as long as a Form 706 is filed. 706 is the estate planning, estate tax return. It has to be filed to get portability. Most clients are not subject to estate tax. 99 point, I don't know, I think it's on the next slide. 99.67% is the estimate by the Congressional Budget Office of the U.S. population will escape estate tax because the exemptions are now $5,450,000 and increase based on the CPI. That's great. I have no problem with that. If they repealed the estate tax, I'd have no problem with it because we're going to be busy the rest of our lives. Estate planning, again, is more than just tax planning. And the idea is to understand that it's not just tax planning that drives our planning process. Although state estate taxes still exist. In DC, we have a $1 million exemption. The DC Council wants to increase it to match the federal exemption, but the feds won't let them because of all their marijuana shenanigans. Oh well. Maryland is steadily increasing their exemption to $5,450,000 or whatever the federal exemption is, and by 2019 it should be caught up. So every state is different. Every state has different laws. Florida doesn't have an estate tax. Virginia does not either. But who knows? They come back. So planning is an ongoing process, and the idea is taxes aren't just driving it, but they are important. These are the things that are in detail in the rest of the slides. So all I'm going to do is talk about these generally, and then you can refer to the rest of the slide because it goes into, okay, how can I benefit out of this? How can we work as a team to generate more work for the accountants, for the insurance folks, for the financial advisors in the room? If you see a client with an old will or trust, an old is defined not only by the time that it was executed, but also what may have transpired since execution. So 2013 was when all of the tax changes were enacted. Their trusts and their wills may be old by definition if they haven't morphed to take advantage of current law. That's a reason to have an estate planning review. What will that do for you? That embeds you with the client. It may enable you to get more assets under management. It may generate thoughts of generating insurance. There may be more tax returns, which I know you want to prepare. If we've got minor kids, that's a no-brainer. Guardianship, and then managing trusts in the event that there's death. Do you let the guardians control the assets? There's a conflict of interest between the guardian and the trustee. If the guardian is the trustee and they have access to the assets, are they acting in the child's best interest always? Who's watching over them? These are issues that come up in the estate planning process. The blended family situation is really complex. Kids from first marriage over here, kids from first or second marriage over here, kids from this marriage together. How do we treat all these kids? You'd be amazed. That's where the estate planning fees tend to rise, is where we know we have a blended family situation and there's not agreement as to what's going to happen. Because everybody's got different views of the way the world should work, particularly depending on where the wealth came from. Special needs children, we have, Catherine here really does a lot of work, not only with the elder law bar, but also mentally disabled kids with Asperger's, where we need special needs trusts built, and we have specialization in that. You need an estate planning lawyer involved in that because the child may, in fact, qualify for federal or state benefits, and we want to structure their inheritance so that it doesn't jeopardize that. Problem children, that's about 50% of my clients. There's someone who always has a kid. I had a call the other day, this was really good. Call the other day, the client calls me, she's been a long-term client, she's got a nice size estate, about 6 or 7 million in assets. And she says, I need a bankruptcy lawyer in Nevada. I said, why do you need a bankruptcy lawyer in Nevada? She said, well, my son's in jail and he has to declare bankruptcy and we need to get somebody down there. So we found her a bankruptcy lawyer for that. But you just never know. Son's in jail. Red flag.
Poor judgment.
Go back. Well, whatever. We got to go back and make sure that her estate planning documents are structured so that it doesn't just leave the assets to the kid who's in jail and who's probably a ne'er-do-well, and she admits it. If you're single, you're divorced, you're a widow or a widower, special estate planning needs to be done. We need to get everything into the revocable trust. We need to make sure that advanced medical directives are up to date so that the spouse is not named. And we've got somebody in spot number 1 to make decisions for you if you can't make decisions for yourself. Other issues that you should consider on your checklist for your clients when you're sitting down with them. An unfunded trust is a bad trust. It's a worthless trust. What do I mean by unfunded? Unfunded means you've got a revocable living trust for your client, but they haven't put the assets in it because, they'll worry about that later. Or they were told by the estate planning lawyer, you don't have to worry about anything. It's all going to go into the trust. But what the estate planning lawyer who said that didn't tell them was that it has to go through probate. And probate, again, it's costly. In Virginia, we have a probate tax, which may amount to as much as 1% of the fair market value of the assets. We don't want that to happen. Fund the trust. You all can help do that. Get the assets in trust. As part of your fee or as for an extra fee, whatever you're going to do, get the assets in trust. Work with the attorneys or their paralegals to get the assets in trust. We have paralegals, 2 of them. In my group alone, that's all they do. Is fund trusts. Preparing deeds, assignments of business interests, helping clients with beneficiary designations on IRAs and 401ks. We'll help you with that. but that's an hourly fee. Get the financial advisor to do that. You guys do that. Help them with it. That gets you understanding how their estate plan works, understanding more about how to fund a trust and why to do it a certain way, and get you more involved in their assets, and actually may allow you to accumulate more assets under management. Unmarried couples, obviously in the gay and lesbian community, we've got the Windsor case in the U.S. Supreme Court, which has led to several IRS pronouncements, which basically treats them, if they're married, as married couples for all purposes in tax. But if they're unmarried for whatever reason, they're living together, first thing you look at is whether or not there's common law marriage. Virginia does not recognize it, but DC does. Maryland does. What does that mean? And are they entitled to marital benefits as a result of it? If not, or you don't want to have marriage provisions in the trusts or the wills, you've still got a plan for it. Because you want to take care of your significant other. Large IRAs, providing for beneficiary designations, the IRA legacy trust we talked about, different ways of handling them so that it doesn't trigger immediate taxation or exposure to creditors. Charitable planning is a huge part of my practice. I serve on a couple of charitable boards. I've always been involved in planned giving initiatives for the University of Virginia. I'm involved with the McIntyre School of Commerce. I've helped William and Mary with theirs, Northern Virginia Family Service. There are different folks that have needs as charities. You can help them with that. Community Foundation of Northern Virginia, one of my partners is on the board there. You can help with that as well. We can help with that in terms of the planning from the client's perspective, making sure that the assets get directed in the right way and handled, structured in the right way. Oh, and by the way, in most cases, if there's enough assets under management, you can be the financial advisor, if you're a financial advisor, managing those assets through the community foundation or whatever, through Fidelity, and get credit for those assets in your portfolio for fee purposes. Business owners is another big part of my practice. Business succession planning. Planning not only for estate planning, but also what happens to the business. How do we preserve the business for the next generation, whether it's family or management, because there may be people who you've worked with for the last 35 or 40 years you want to take care of. I'm dealing with that constantly. It heavily involves the use of life insurance. It may not necessarily involve life insurance, though, particularly if the individual is not insurable. There are other ways of planning for that. It's not just a buy-sell agreement. It's a lot more involved than that. And then pet owners. You can have a pet trust in Virginia and DC and Maryland. Not like Leona Helmsley is anticipating, where she set aside millions and millions of dollars for her pet, or the I can't remember the heiress in Florida, who set aside $8 million in trust for her Chihuahua. No, but the idea is setting aside a reasonable amount for the care and feeding of your pets if they're important, and putting somebody in charge of that. It's legal. So the next several slides get into the details of how we can do that for you. Thank you so much for your attention today. The second session is concluded. We're going to have a third session on May. It's in the folder. The flyers in the folder coming up. May 18th. I look forward to seeing you all here. We're there, and thanks for coming.